without a court order. Government seizes property without a court order. Government seizes bank accounts without a court order. Is that going on? Heck yes. As we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military script circulated within a military venue. The problem is the people don't understand how the entire United States is covered by a military venue. Under the Social Security Act, there was brought into existence 10 federal regional areas. These 10 federal regional areas are the same as a military base. It is not unconstitutional to circulate military script on a military base, as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. The problem the Congress realized was, while Congress could restructure the government agencies into these federal regional areas, the people could not be identified to be within this military venue, but by their own consent. You have to agree to it. The solution was to create another military venue which would trick the people to voluntarily accept recognition that they're within a military venue. Congress solved this problem by creating the zip code. The zip code divides the United States into 10 military venues called national areas. When a citizen receives mail from an agency of the federal government, such as the IRS, in the return address of the federal agency is the district within the regional area the letter was sent from. On the address of the citizen it was sent to is the national area in which he received the correspondence from the IRS. In other words, the correspondence was sent from one of the federal regional areas, a military venue, to one of the national areas, another military venue. Taxing districts are established within one of the federal regional areas, which places the collection of taxes under the martial law jurisdiction. Evidence that there's a military occupation. Military script is circulated for money. Police use the rank structure of captain, lieutenant, sergeant. You don't think that's going on? Police refer to us as civilians. Yes. Courts presume everything. Curfew. How many times have you seen a curfew? I've seen curfews. It's strictly under martial law jurisdiction. State regional areas under metro government provide military venue for the peace officers to enforce a martial law jurisdiction. And then I use some examples in Canada, but there's certainly plenty here. The Lethbridge Regional Police, the Metro Toronto Police Department. This was a war over the intrusion of civil law upon common law. The Court of Diamond v. Harris calls civil law, statutory law, superior equity. It is difficult to see how courts of this state are to ignore the common law rule as a rule of decision when it is made so by statute, and adopt the civil law even though it had the merit of superior equity. We can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It's been replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. And that's true. And how many times have you heard people say that stuff? I've heard it a lot. But common law is still here. You just have to know how to access it. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood. It looks like it's cut off on the side, isn't it? Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. Equity, if equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what is called equity in its place. And this is in the Alberta Judicature Act, and I haven't found anything similar to that here, you know, I haven't looked that hard either. In all matters in which there is any conflict or variance between the rules of equity and common law with reference to the same matter, the rules of equity prevail. That's why they can ignore common law, and that's why they dismissed my case, because I went in there and made common law arguments, and the Crown came in, and this was in Lethbridge, the Crown came in and they made equitable arguments. And so then the court just took the equitable arguments and did whatever they felt like doing. And that's how I got them removed, because I just basically went step by step and I showed how they used their equitable arguments under martial law to violate my rights under the color of law. Yes?
Under Section 1-207 of the Uniform Commercial Code, it says that the UCC was written to supersede or complement the common law, and that it should be used in that manner, but the common law does remain in force. And it says it in section 1-207. I read it in the law library in San Angelo.
Actually, it says in there, if I remember right, it says you can reserve your rights at common law.
I didn't see that part.
Yeah.
But I didn't see the Anderson edition either. I had to pick it out of the other stuff.
You can put down without prejudice. Right. And that reserves your common law rights. But
it also
again,
says,
it comes down to the courts. You know, even though you're making certain pleadings, you know, what are the courts doing? You know, and so what I need to do is look in the rules and the acts and see what they say. But I know that says that in Canada, and that's consistent across all the provinces. There's even federal statutes that talk about that. Well, that says the rules of equity and common law, that equity prevails. My understanding of what the UCC says is that you can reserve your common law rights.
That's right. You can reserve your common law.
Well, but that's not what that says. That says when common law and equity conflict, that equity prevails. Martial law is really no law at all. It's a dictatorship. What is called proclaiming martial law is no law at all, but merely for the sake of public safety in circumstances of great emergency, setting aside all law and acting under military power, a proceeding which requires to be followed by an act of indemnity when the disturbances are at an end. And that's the Attorney General's opinion, February 13, 1857. And this is the Canada Prize Act. Again, it's talking about persons, and I need to get some stuff in here for the Trading with the Enemy Act, because it talks about the same stuff. And the U.S. Declaration of Independence. He's affected to render the military independent of and superior to the civil power, martial law. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to an act of pretended legislation. Well, pretended legislation sounds like color of law, and subject to a jurisdiction foreign to our Constitution, that's martial law. For imposing taxes on us without our consent, martial law. For depriving us in many cases of the benefits by trial by jury, martial law. For abolishing the free system of English laws in the neighboring province, establishing therein a arbitrary government, martial law. Enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. He has abdicated absolute rule, martial law, dictatorship. He has abdicated government here by declaring us out of his protection and waging war against us, martial law. For protecting them by a mock trial, martial law. Causes and necessities for taking up arms. Statutes have been passed for the extending of the jurisdiction of courts of admiralty and vice-admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, martial law, and for altering fundamentally the form of government established by charter, martial law. We saw the misery to which such despotism would reduce us, martial law. A person does not have to consent to canon law. Canon law is just another word for martial law, okay? And you go to the Vatican's website and you can see it. They talk about tribunals and all sorts of stuff. Anyways, a person does not have to consent to canon law. Canon law presumes that the Creator left the Pope everything and he was to be the trustee of the Divine's trust. Since no one rebutted the presumption, they consent to canon law. Happened at the first conclave, I believe, in 1302. From that day forward, any time a vessel financed by Rome, all of them that explode new territory, planted a flag in the name of the church. Since the natives didn't rebut the presumption, everything on that landmass became the property of the Pope. In 1666, King Charles II signed the Sesticate Trust Act. Thus, for the first time, we have a testamentary trust, a trust for the deceased, into which the estate of the deceased is conveyed. At the same time this act was signed into law, the town of London burned. It is under this type of trust that you, if you're a person, are now classified. You're a fictional entity and you legally died at the age of 7 and your property is put into an estate and the government is the trustee. Canon 1170, a divine trust is the highest possible form of trust and unique as the only possible type of trust that can hold actual form rather than rights of use of form being property. Canon 1171, in accordance with these canons, a divine trust can never be terminated. That's why they'll never terminate the Social Security number. You just have to quit using the thing. Canon 1179, in accordance with these canons, every child or higher order spirit that is born from now until the end of time possesses a divine personality through the creation of their divine trust before any other legal entity or claim. That's why they make it mandatory to register the straw man's birth. Again, it's persons. If you're a person, it's mandatory. If you're not, it's not. And that's why we need to stop doing that. And how do we do it? We record it in the family Bible. That's how it's done at common law. You get these big Bibles and you can buy them in a bookstore. I might have one here. I'll bet I do. I'll go get it. But you just, in the front of the Bible, it's got a place where you record genealogy, family history, births, marriages, all sorts of stuff. And that's how they do it at common law. And I talk to border guards, they know all about it. We need to start doing that stuff. If you go back here, a divine trust can never be terminated. Okay, that's why the headstone is always in all block capital letters. Okay, that's why the headstone's in all block capital letters, because that's a trust laying there. Trust, an equitable right, title, or interest in property, real or personal, distinct from legal ownership. Okay, it's all about equity, and because there's no common law, the courts can do whatever they want. Beneficial interest, that right which a person has in a contract. Beneficiary, the term frequently used synonymous with the technical phrase assesticate trust.